Right, good morning, everyone. My name is Sterling Higa, Chairperson of the Authority. I'd like to call to order the January 7th, 2026 public hearing of the Hawaii Community Development Authority. The time is now 9 a.m.
Thank you, Chair. In accordance with Section 92-3.7 Hawaii Revised Statutes, the Hawaii Community Development Authority is holding today's public hearing virtually on Zoom and in person. The Zoom link details were included in the public hearing notice. Therefore, members of the public are welcome to join us on Zoom and also at our physical meeting site at the American Brewery Building, 547 Queen Street, second floor boardroom, Kaulu, Hawaii, 96813. The HCDA communications staff is hosting this meeting. Once this meeting begins, everyone will be muted for clearer audio. Board members, if you have any comments or questions, please unmute yourselves to speak. It is important that all individuals clearly state their name, pseudonym, or other identifier name each time prior to speaking. If you are providing verbal public testimony, your name will be called accordingly. If you are attending in person, when your name is called, please come to the front of the room. And if you are attending virtually, please turn your video on only while providing your testimony. In either case, please clearly state your name and affiliation and proceed with your testimony. Oral testimony will be limited to 3 minutes and will be accepted only on matters directly related to the public hearing subject. Keep in mind that this is an opportunity to share your thoughts with us. If you ask questions during your testimony, neither the board nor the staff is required to provide an answer. If the authority's connection for the remote meeting is lost, the meeting will be recessed until the connection is restored. If the connection cannot be restored within 30 minutes, the hearing will be reconvened on Thursday, January 8th, 2026 at 9 a.m. at the same physical location on virtual Zoom link as today's hearing. Thank you. Chair.
Thank you. HCDA board members, please remain visible and audible during the hearing. Also, please acknowledge you are present by either saying here or present. Let the record reflect that the following Kalailoa members are present. Vice Chair Ishii.
Here.
Thank you. Secretary Lidstone.
Here.
Thank you. Member Miranda Johnson.
Here.
Thank you. Member Anderson.
Here.
Thank you. Member Evans.
Here.
Thank you. Member Streitz.
Here.
Thank you. Member Duvachel.
Here.
Thank you. And Member Gordner.
Here.
Thank you very much. Wow. Individuals from the public who have requested to provide verbal public testimony on a specific agenda item are on standby and will be permitted to provide testimony respectively. Would counsel for the applicant make their appearances at this time?
Good morning, Chair Higa, members of the authority, Executive Director Nakamoto, and HCDA staff, Brian Kang, appearing on behalf of Gentry Kalailoa LLC today.
Good morning.
Good morning.
Good morning.
Okay, legal basis and purpose. Today's hearing is being convened under the provisions of chapters 15-215 Kalailoa Community Development District Rules and 15-219 Rules of Practice and Procedure, Hawaii Administrative Rules, and section 206E-5.6 Hawaii Revised Statutes to consider the following matter. The applicant is Gentry Kalailoa LLC. The development permit number is KAL 25-010. The project is Kaulu. The tax map keys are 19-1-93 193-:001 002 009 010 011 013 014 015 016 17 018 019 020 021 022 023 024 025 026 027 028 029 030 031 032 and 033 and tax map key 19-1-013:198. Project location is between Roosevelt Avenue, Kopahe Avenue, Boxer Road, and Kawakila Boulevard. The project description under a development permit KAL 21-005 that was originally approved in February 2022. The applicant is constructing a 390 unit residential project on an approximately 29.8 acre site along Roosevelt Avenue between Kopahe Avenue and Kawakila Boulevard. The applicant proposes to amend this development permit to utilize pre-existing reserve housing credits for approximately 46 out of the 88 required units in the reserve housing program for the project. In addition, the applicant also intends to use dwelling unit revolving fund equity program for designated units within the project. Legal notice, a public hearing notice was published in the Honolulu Star Advertiser, Maui News, the Garden Isle Hawaii Tribune Herald, and West Hawaii Today on Thursday, October 30th, 2025. Presentation public hearing. A presentation public hearing for this development permit application was held on December 3rd, 2025. Chair.
Thank you. I'll briefly explain our procedures for today's decision-making hearing. Prior to this hearing, authority members received both the HCDA staff's and the applicant's proposed findings of fact, conclusions of law, and decisions of order. So first, HCDA staff will present its recommendations. Then the applicant will be afforded up to 15 minutes to present their closing arguments and present any additional facts not already included in their respective proposed finding of facts, conclusions of law, and decision and order. And finally, we will hear testimony from the public before continuing on to decision-making. Only members of the authority and the executive director will be permitted to ask questions of the staff, the applicant, or individuals providing testimony. I'll be acting as presiding officer for this hearing. Are there any questions as to our procedures? Seeing none, we will now begin our proceedings. We'll begin with a presentation by HCDA staff of its proposed findings of fact, conclusions of law, and decision and order by HCDA's Director of Planning and Development, Mr. Ryan Tan.
Good morning, members of the authority, members of the public, the Gentry team and council. Before we start, I did want to acknowledge the work of our staff planner, Mr. John Sheehan, as well as the rest of the team, including Ewan, Armain, Bobby Lynn. And we do acknowledge the Gentry team and council for the time spent after the presentation hearings, and really appreciate their willingness to engage in meaningful discussions on this. Members, you do have copies of the staff proposed findings of facts, conclusions of law, and decision and order in your packets. First, we wanted to address some of the outstanding questions that were raised by the board during the presentation hearing. First of all, regarding the intent of the Wakea Gardens Building 77 project and the future sale of reserve housing credits. So as documented in the decision and order, or DNO, for the Wakea Gardens project, Hunt's affiliate fully intended to transfer the excess reserve housing credits above the 15% threshold to other future developments, either within Kaulu or elsewhere on Oahu. Such transfers were explicitly allowed in the Wakea Gardens DNO number 4, that's on page 21, that was included in Exhibit 4 during the presentation hearing. We've also added this as a findings of fact, number 40 on the proposed staff DNO, and that's on page 9. Secondly, the relationship between the reduction of on-site reserve housing and the long-term affordability needs of Kailua residents. So the Kailua reserve housing rules requires new developments on lots over 40,000 square feet in size to reserve a percentage of its floor area for residents in the low income or moderate income ranges, but only for a regulated length of time. So for where for sale units are developed, 20% of the additional floor area needs to be reserved for a term of 5 years. Where rental housing units are developed, 15% of the residential floor area needs to be reserved for a term of 15 years. After the regulated term ends, the units can be sold or rented free from any transfer or price restrictions, except for any applicable equity sharing requirements. This is in section 15.216-35D on page 216-14 of the Kailua rules. So while the proposed project amendments do reduce the number of on-site reserved for sale units and shortens the regulated term, the overall impacts on addressing the long-term affordability needs is less clear. The number of reserve rental housing units at YK Gardens is not affected by this. So, so on to a third point, third question at the presentation hearing, which regards the value of reserve housing units relative to market rate units. So in addition to Gentry's own testimony, there were also comments which revealed that the market rate units at other projects in the region, such as Ho'opili, are sometimes priced similarly or cheaper than Kaulu's reserved housing offerings. So even within Kaulu, staff have found that the reserve units are sometimes a relatively lesser value proposition than the market rate units. So I'll explain that further. It is these such factors which staff considered in developing the requirements in an affordability study. In June 2025, for example, Gentry released 4 reserved and 2 market rate 3-bedroom, 2-bathroom units for sale. The reserve units were priced at $685,000 and the market units were priced at $750,550. What this means is that the reserve unit, one reserve unit was priced at $629.02 per square foot, and 3 reserve housing units were priced at $634.26 per square foot. The 2 market rate units were priced at $628.08 per square foot. So when looking at the value proposition of these offerings, each $10,000 spent would get you 15.77 to 15.9 square feet in a reserve unit and 15.92 square feet in a market unit. So essentially your money would go slightly further in a market unit. Note that these comparisons do not account for different factors such as unit layout, location, views, laundry facilities, or other housing characteristics. Fourth question that was raised was regarding floor area. And so under the 2012 residential unit uses in T3 requires 10 to 20 units per acre. The project has 390 units in about 29.8 acres. So the density is about 13 units per acre. Under our proposed rules, we have a proposed maximum density of a 1.5 floor area ratio. The project site area is approximately 1,298,408 square feet in size, has a proposed floor area of 530,789 square feet, and thus a project density of about 0.4 floor area ratio, FAR. So while this floor area ratio is much lower than the proposed transit zoning, I did want to note that water availability is one of the other factors that is also constraining overall development within the district at this time. Okay, moving on to introducing kind of our comments on the decision in order. Staff did consider the applicant's request to apply pre-existing reserve housing credits originating from the Wakea Gardens Building 77 project towards 46 of the project's reserve housing units. The staff acknowledges that the Kalailoa reserve housing rules permits the generation and application of the reserve housing credits. It is not the intent or purpose of the proposed staff DNO to reduce the value or legitimacy of these credits. As a result of numerous discussions since the presentation hearing, staff have obtained more insight into the project's sales and marketing practices, rate of sales, and inventory of reserve housing units for the project. The proposed staff DNO is an attempt to balance the needs voiced by the applicant with the intent of the Kalaeloa Community Development District rules, the Kalaeloa Reserve Housing rules, the Kaulu project goals set forth by Gentry, and the reality of market conditions for the Ewa Plain, a market which the applicant has deemed distinct from Metro Honolulu. As a development agency, staff does wish for Gentry to successfully complete the Kaulu community, including on-site reserve homes. It is staff's belief that with the proposed DNO and the conditions therein, Gentry's reserve housing program will succeed. In terms of context, we just wanted to share some of our updated understanding and clarify some slight nuances based on our discussions with Gentry since the presentation hearing. First, regarding the inventory of units. So when the application was filed, Gentry indicated that there were 15 housing units in standing inventory and 19 reserve housing units have been sold. As of December 2025, however, the applicant notes that they have sold 23 reserve housing units and had 14 reserve housing units in standing inventory. With regards to sales patterns, Gentry has indicated that housing sales generally follow a nonlinear pattern, yet has reported its reserve units as selling at a rate of less than one home per month. Representing a nonlinear relationship as a linear rate could potentially oversimplify and mislead its interpretation. Reported sales data could vary greatly depending on natural sales patterns or the time of year when such data is collected. This does have ramifications for time or quantity-based thresholds such as sales triggers. According to updated information provided by Gentry, 8 reserve units were sold in 2024 and 15 reserve units were sold in 2025. In 2025, the only months when Gentry did not sell at least one reserve housing unit were January and October. Gentry recorded the sale of 3 reserve housing units in September 2024 and 2025, perhaps evidence of a peak in the selling season. In 2025, Gentry sold 2 reserve housing units in March, November, and December for a total of 6 reserve units, with 1 unit in the remaining months of that year. In 2024, Gentry reported 2 reserve housing units in July and October, 4 total, with 1 reported in June. Next, with respect to the carrying costs, in the application and at the presentation hearing, Gentry testified that the financial burden associated with the carrying costs of the 15 already constructed but unsold reserve housing units could lead to significant delays if Gentry is not allowed to apply the reserve housing unit credits. Of the 15 unsold reserve housing units available for sale, Gentry indicated that some had been on the market for over 20 months and 9 had been on the market for over 6 months. Since the presentation hearing, Gentry had explained that they focus on 2 metrics when assessing their housing inventory. The first is the time a unit is available for sale, and the second is the time duration that a unit is considered as standing inventory. This is the time between a certificate of occupancy is issued and the closing of a sale. So this latter metric is actually when the applicant incurs the associated carrying costs that they talk about. So when looking at the time that a unit is available for sale, the first metric, 15 units were available for periods between 6 and 20 months, and 2 units were available for longer than 20 months. When looking at units that were actually standing inventory, 5 units were standing for durations between 6 and 20 months, and no units were standing inventory for durations greater than 20 months. So the median time available standing inventory was the median time available was 9.1 months. And the median time standing as inventory was 3.8 months. So from this perspective, the carrying costs may not have been as significant as what the applicant was portraying in the application and the presentation. Fourthly, with respect to market conditions, within the broader context of the state's housing deficit of 50,000 units, even with the market conditions, it is hard to believe that the reserve housing terms alone are to blame for this. Since market rates or units are also underselling, and based on the testimonies provided at the presentation hearing, it suggests that Gentry's offering in terms of product, design, or price may exceed the market demand. So as reported in the application and as stated at the presentation hearing, the market rate units were also selling slower than expected. To claim that the success and timely completion of the project rests on the application of reserve housing credits on a minority of units is a baseless argument. So fifthly, lastly, kind of general concerns. So at the presentation hearing, the applicant did make its goals clear. Gentry does desire to complete the project and fulfill its commitments in accordance with the Kaulu Community Development District rules without asking for that type of suspension. This is found on page 32 of the hearing transcript. As mentioned previously, we would like to point out that at the presentation hearing, when asked what the impact on Gentry would be if it is not permitted to use that reserve housing credits and is to maintain and incur these costs, those costs of those already constructed reserve housing, Gentry replied that the timeline could double. This is found on page 31 of the presentation hearing. Additionally, given that HCDA has already approved use of reserve housing credits to address those concerns, staff considers that issue resolved. It is staff concerns that the remainder of these negotiations represent a scope creep of the requested amendment as stated in the presentation hearing. So with regards to the specific exception requests, which were filed on Monday, January 5th by Gentry, we do acknowledge the quick turnaround by Gentry, and they acknowledge to discuss them this morning. So argument A of the exceptions, that's on page 9. The Gentry's request is to modify staff DNO number 7 to add a 1-year time period in addition to sales trigger to allow Gentry to request the use of the second reserve housing unit credit tranche, which is equivalent to about 32 units. So the proposed staff DNO already satisfies this concern through the additional proposed release of the credits, reserve housing credit tranche 1, which permits Gentry to apply the reserve housing unit credits towards 15 specific units in standing inventory that we identified with the applicant. So argument B on page 14 of the exception requests that to delete the staff DNO conditions number 2C and 9H, which is to eliminate the affordability study. Staff developed the requirement for an affordability study to address concerns raised by the authority, the Office of Hawaiian Affairs, and other testifiers during the presentation hearing regarding the long-term affordability, value proposition, and a desire for deeper affordability. The Office of Hawaiian Affairs comments are referenced in the proposed staff findings of fact number 119 on page 26. The affordability study is intended to help evaluate if Gentry's pricing supports its goal to broaden the range of reserve housing prices and to provide housing for buyers who are unable to obtain market rate housing, as noted in staff findings of fact number 57. Gentry noted that at Kaulu, its reserve housing and market rate homes both sell to households earning closer to 140% of the active average median income, which is also the income limit under the Kalailoa reserve housing rules. Some of Gentry's reserve housing units are priced higher than other market rate units in the area. Per Gentry's testimony, it is staff's concern that market rate in the Ewa Plains should necessarily be lower than in Metro Honolulu. Gentry testified that the Ewa Plain housing market is distinct from that of Metro Honolulu, and thus it would not make sense to hold prospective buyers in Kaulu to the same income limits for Metro Honolulu, which include areas like Kaka'ako. The U.S. Department of Housing and Urban Development cites that the median income for metro areas within the state of Hawaii is $127,000, while the median income for non-metro areas is $102,900. So it's less. Gentry suggests that this affordability study should be commissioned by HCDA. We disagree. The pricing and affordability of Gentry housing units are Gentry's responsibility. With regards to argument C, which is on page 15 of the exception, this requests the amendment of staff D&O condition number 5 to remove detailed requirements regarding the online marketing materials. So the project website does not explicitly mention the existence of its reserve housing program or provide easy access to information about it. It is staff's sincere belief that with improved online presence and marketing materials, a reduced regulated term, Gentry's reserve housing program can succeed. The proposed staff D&O condition was intended to provide requirements for the website and marketing materials that would increase awareness about the reserve housing program and directly address Gentry's stated problems with unsold reserve housing units. The specificity of these proposed requirements is also consistent with the existing notice requirements in the Kalailoa reserve housing rules, Section 15-216-31C Hawaii Administrative Rules. That section describes specific requirements for the notice of proposed sale of reserve housing, such as a general description of the project, proposed sale of reserve housing, qualification requirements for the purchase of reserve housing units, including maximum income limits and other reserve relevant eligibility restrictions, the first come first serve or lottery basis of the sales releases, deposit amount and acceptable modes of payment and deadlines for submissions of application. Lastly, with respect to argument D on page 19, which requests the elimination of staff finding of fact number 109 and the replacement of staff D&O condition number 17 with Gentry D&O number 9, to allow the reserve housing floor area credits to also apply to the public facilities dedication requirements. The Kalailoa Community Development District Rules, Section 15-215-64A, Hawaii Administrative Rules, and Kalailoa Reserve Housing Rules, Section 15-216-18A2, Hawaii Administrative Rules, both state that residential floor area for reserve housing shall be exempt from the dedication of public facilities. Gentry has asserted that the use of credits to satisfy reserve housing floor area requirements should similarly make the application of that floor area exempt from public facilities dedication requirements. Staff believe that this is incorrect for the following reasons. Number one, the use of reserve housing credits increases the market rate residential floor area at Kaulu that would trigger additional public facilities dedication requirements. Number two, the reserve housing at Wakea Gardens were exempt from public facilities dedication requirements. Also exempting the converted floor area at Kaulu would essentially double count the reserve housing floor area as physically existing at both Wakea Gardens and Kaulu. This is not the case. The excess reserve housing required at Wakea Gardens is just an off-site location which is allowed to satisfy the requirements at Kaulu and just happens to have been built earlier than Kaulu by a separate developer. Third, furthermore, the proposed staff DNO number 11, which is also the petitioner's DNO number 7 as amended, actually releases the requirements or attributes of reserve housing from the associated floor area where the Wakea Garden reserve housing credits are applied. The associated floor area thus takes on the attributes and rights of the market units and should also take on the associated requirements for specific public facilities dedication. I'm now going to briefly summarize the findings of fact as I typically do, which starts on page 2 of the staff DNO. So again, page 2, findings of fact number 1 through 17 is a procedural history regarding agency letters. Starting on page 5, findings of fact 18 through 27 discusses the December 3rd presentation hearing. Starting on page 7, findings of fact 28 through 31 discusses the Kaulu master plan. Starting on page 8, findings of fact 32 to 35 discusses the Kaulu LLC and Gentry Homes. Starting on page 9, numbers 46 through 31, 36 through 43 discusses the Wakea Garden apartments. Starting on page 10, numbers 44 through 100 describes the project status, including construction to date, status, sales status, marketing efforts, and impacts. Starting on page 22, numbers 101 through 112 discusses the amendments to reserve housing provisions, including public facilities and compliance. Starting on page 25, findings of fact 103 to 123 discusses government agency comments. Conclusions of law starts on page 27. The DNO decision and order starts on page 30 as follows. Page 31, DNO number 1 is the reserve housing requirements. Page DNO numbers 2 and 3 is the amended reserve housing development plan and program. Page 32, DNO number 4 is the shortened regulated term from 5 years to 2 years. Page 33 is DNO number 5, which is the updated marketing materials. Page DNO number 6 is the first reserve housing credit tranche of 14 units. Page 34, DNO number 7 is the second reserve housing credit tranche, which is 32 units, which is effective upon the sale of 15 reserve housing units. Number 8 is a requirement to provide 49,525 square feet of on-site reserve housing and no option for additional credits or payment in lieu. Page 35, DNO number 9 is reasonable considerations for supplemental reserve housing credit requests. Page 36, DNOs 10 through 14 is the application of reserve housing credits and continued submittal of reserve housing unit sales prices for authority approval. Page 38, DNO number 15 is semi-annual reporting, which is new. Page 39, number 16 is reserve housing credit balances. What happens with that? Page, number 17 is public facilities dedications. Starting on page 40, is 18 through 22 is compliance with rules, covenants, and agency comments. And page 41, number 23 is continuance of recorded findings of fact, conclusions of law, and conditions from the original permit, KAL number 21-005. In conclusion, the staff's recommendation is for the board to adopt the staff's decision in order.
Thank you, Ryan. Members, do we have any questions on staff's proposed findings of fact, conclusions of law, and decision in order?
Yeah.
Member Evans.
Ryan, how does the staff proposed affordability study differ from the information that you have just provided to us on the affordability of the Lycia units?
So the staff affordability study is intended to, I guess, go into more detail and to look more specifically at how the pricing at Kaulu of the units is in context to the different HUD levels and affordability, that's applied within the island, city and county of Honolulu versus kind of the non-metro areas. So it's a more detailed analysis.
Okay, thank you, Chair.
Thank you. Members, any other comments or questions for Mr. Rantown? Seeing none, Member Schwartz.
I just had a quick clarification question on the justification for removing or reducing the restriction period for all the remaining reserve units, which would be after the credits are applied.
Anyway, this is staff member John Cheney. John 13. The intent to reduce the regulated term is, I believe, what you're asking. Right. The intent is actually to make it easier for Gentry to sell its remaining reserve housing units. So we're trying to be responsive to some of the concerns that they've raised in terms of the difficulty of selling reserve housing units, especially with respect to its attractiveness. So the regulated term, prevents it provides another barrier for homeowners to sell their units. So for example, military members, if they're trying to get their first time home, but they may have a limited time on the island, the longer regulated term may prevent them from accessing some of these homes. So the reduced regulated term is just intended to make the units more attractive.
Okay, yeah, because I guess I kind of have issue with the comparison to other developments in the other area, like the example of Old Peely, because those are subject to affordable housing requirements as well. And just because they don't have a reserved or affordable unit on the market at the time, I don't think that is really like comparable to justify, the other reserve houses in Kaulu to get out of that kind of requirement.
Okay, noted.
Members, any of them? Member Evans.
Maybe a follow-up to Tim's question. Are the reserved units getting any state financial support from HCDA in this particular Wakea Gardens? Or is the reserve units are based on our law and rules, have imposition of restrictions because of our regulatory authority to grant a development permit?
To my knowledge, the reserve housing at Waikea Gardens is subject to our regulatory approval. I am not aware of any direct support from HCA at this time.
Thank you.
Members, yes, Member Duvichel.
Do we know if the income limits that are being used by Gentry for the reserved housing are up to date?
I believe so. So every Gentry is required to come to the HCA board to approve every increment, every sales increment of reserve housing. And so those are updated.
To qualify that a bit though, is that this is the first indication that the market operates differently than Metro Honolulu. So that's why, yeah, there's that shift towards the affordability study.
Right.
Right.
So the income limits for the reserved housing for Kaulu specifically, are they operating at its full capacity of offering 140% or offering the highest income limit to attract folks to apply?
I have to defer.
I believe so. The way I understand it is that's the maximum threshold.
And we know that that's the current income limit.
Yes.
Yeah.
Yes, it is.
And so the affordability study that's been doing or maybe gonna happen is, I just wanna make sure that we're actually targeting the right folks who qualify, that those income limits are accurate and that we're going after the right people.
Right. I think by specifically targeting non-metro numbers and income ranges, yeah, we're going to tease out exactly that. Yeah. In particular, like distribution of income as reported in like census data, for example, in that EVA plane would probably be a good indication as well.
I'm sorry to interrupt, but who is speaking?
As
so sorry.
Member Duvichel,
No,
and then John Chinnen, who's on HCDA staff.
Thank you.
Member Gordner.
My question also relates to the income limits. I believe Ryan testified that there's a significant spread between the Metro AMI, the non-Metro AMI, 127,000 versus 102. So I just wanted to be clear, when we say that the limit, the income limit for this development is 140% AMI, is that calculated off of that 127 right now in the reserved housing rules? Or is it calculated more locally to Kalailoa?
No, it's I believe that it's calculated based on the HUD limits, so the countywide.
Okay, thank you.
Members, any other comments or questions for staff? Member Strites.
Yeah, I just wanted to state my other concern, I guess, up front with the credits. So I do appreciate you, walking through the report and how, that is allowed through the Wakea DNO. I think though that kind of how it's being used in this case is counterproductive to the intent of the Kalailoa reserve housing rules, and that, we're trying to provide more low and moderate income housing. And by using the credits, they're essentially putting money into buying the credits and then finding the facts that even says that's gonna result in those units being raised 3 to 4%. So we're increasing the price of the reserved units versus putting that money into lowering the price of those units, and then perhaps giving credit for, having a reduced AMI level from where it's at right now. So I don't know if that part is allowed, but I think going forward, the board should really consider those aspects and perhaps even look at tying expiration dates to the credits and or having those be shown to be part of the pro forma of a project, so that we know that if they are being used outside of the project for sale, that they're financing actually affordable units. But this is over, like a decade ago that they were issued.
Yeah, thank you, Member Streitz. And, the Kaulu reserve housing rules were last amended quite a while ago. 2012, I believe, in that time frame. And so one of the things that we were thinking is that, as we kind of move forward, taking a fresh look at these rules, and how we apply reserve housing, how we implement reserve housing in this district would certainly be warranted.
Thanks.
Members, any other comments or questions? Seeing none, we'll move now to council's closing arguments. And then just as a note for board members, we'll have chances to ask questions of the council for the applicant. And then following that, should we move into deliberations and decision making, there's further time for discussion and questions. So council, closing arguments. You have 15 minutes.
Thank you very much, Chair Hagan. Appreciate it. And we appreciate the board's and the staff's efforts and time on this. As you can tell from the timing of the filings, all of this occurred during the holidays when folks had many other things to do. So we really appreciate all the efforts involved in this. So it wasn't for a lack of, I think, reasonable good faith efforts on all parties' parts to try to reach an agreement on this. But Gentry did end up respectfully disagreeing on certain aspects of the staff proposed decision order. To step back a little bit, the parties did agree on a general framework on using the credits in a way that would provide a first tranche and a second tranche, as noted. The first tranche is essentially about 30% of the credits originally requested by Gentry, with an opportunity for Gentry then to appear before the board in a regular meeting to request a second tranche. And to step back even further a little bit, Gentry filed this application for the use of the wet care garden credits, really to keep the project on track. That was Gentry's goal with respect to this proceeding. And the way that the project is designed, as the record indicates, the project integrates the reserved housing within the market housing structures. And therefore, the entire project needs to be designed, planned, and constructed together. The issues with selling the reserved housing units or the absorption rate for the reserved housing units, therefore affects the ability for Gentry to continue to plan, design, and construct the market units. And in this particular project, this is Gentry's bread and butter. It is a workforce housing project. It is not a luxury project, and it will remain so, even with the application of these credits. The staff indicated, and Member Streitz, I know you indicated as well, that yes, once the credits are applied, Gentry will likely increase the prices to the market units by about 3 to 4%, which Gentry believes is reasonable and is consistent with the market and Kaulu law. But the point is that, from Gentry's perspective, this proceeding was to allow Gentry to continue the project as a whole to provide both reserved housing as well as continued workforce housing for the community. The other kind of forest for the trees issue is, the fundamental nature of these credits. And we understand the board has expressed, concerns about the use of the credits. Gentry points back to the fact that, the Waikea Garden DNO really doesn't condition these credits. It does indicate that obviously the board has the authority to approve the use of the credits. It doesn't say anything further, with respect to that. And, Gentry understands, perhaps the board has raised some concerns with respect to that. But from Gentry's perspective, in looking at these development credits, these reserve housing credits, looking at the Waikea Garden DNO, it does allow the application of the credits, and these credits for purposes of, the regulatory compliance really are no different from constructed reserve housing, physical reserve housing on site. And that's important because, Gentry has to be able to rely on that based on the Waikea Garden DNO. Other developers need to be able to rely on the use of credits, which again, kind of provides some flexibility for a developer to use excess resources that were generated in the past more flexibly in the future. And in this case, Gentry believes in a down market for reserve housing and for other types of housing, the credits are particularly suitable for this type of situation versus when, if Gentry were to come in during expanding market, to try to attempt to use these credits. The use of these credits allowed Gentry to kind of smooth out and to kind of anticipate and to try to plan for these issues where the reserve housing units are not selling well, so that it can continue the project and continue to provide both market as well as the reserve housing units. So the kind of the fundamental nature of these credits are important, I think, to keep in mind as you look at this. With that in mind, let me circle back to the first of Gentry's exemptions, and this has to do when Gentry will be able to update this board during a regular meeting on the status of Kaulu, as well as to request the use of the additional credits in the second tranche. The staff decision order sets the threshold, of the, I believe, the 15 additional reserve housing units. Gentry's DNO also requests a time threshold, a year. And the evidence before this board in the record is that the 15 reserve housing units in the current market could take well over a year. And I understand staff's comments with respect to, well, it could be faster. It could be certainly be faster. And I think in staff's mind, given the additional considerations, given the lesser regulated term perhaps, as well as, reducing the threshold to the 15 units from the original proposed threshold, it could be quicker. But I think the record before you as well is that in Gentry's experience over 6 decades of building homes, developing homes, trying to sell homes in this market, the market is not linear. And although I think Gentry has quite a bit of experience, and the record supports this, in trying to divine the market and trying to predict the market. The reality is, and I think everybody in this room can agree, ultimately, no one can know for sure. And, in Gentry's view, ultimately, it doesn't matter who can best divine the future. It doesn't matter who necessarily is right or wrong on this, but Gentry believes that there is a significant risk if Gentry is unable to sell these homes timely, these reserve housing units timely, and it cannot come back to the board within a reasonable time period to request relief. Gentry is not asking this board to automatically grant the second tranche. Gentry is not asking this board to say, yes, once you come in, let's allow you this relief. All Gentry is requesting with respect to the time threshold is a reasonable opportunity to come back to this board within a year, which Gentry believes is reasonable, and a good test of the market, frankly, to see where everything is. And if Gentry has continued issues with selling these reserve housing homes, to make that request for further relief through the second tranche. Gentry fully understands that's going to get questions with respect to what have you been doing and, what is the market like? But, with respect to Gentry's DNO, that's all Gentry is asking for a time period for Gentry to return to this board. And Gentry believe that time period is reasonable and request that that time period be incorporated into the condition on this. Now, Gentry's second exemption to the staff DNO was requiring or the request by the staff for the affordability study. And I'll primarily rest on the exemptions that Gentry filed here. But I think that as Mr. Tam indicated, the study was intended to go into more detail, look more specifically about how pricing of Kaulu units in context to different HUD levels, et cetera, apply to island versus metro areas. This is the first time we're hearing, exactly what the rationale of this study is. And although we understand it, largely this information is part of the record already. And respectfully, issues regarding reserved housing, affordability of reserved housing is a very complex issue. It's a holistic issue. It's an issue in Gentry's view that would be better suited through this board's powers, basically, to initiate some additional rulemaking or some investigation with respect to that. And Gentry is glad to participate in that, but to place the burden specifically on Gentry with respect to this study, well, Gentry is trying to keep this project on track and move it forward. Respectfully, Gentry believes resources could be better used and better utilized for the board's authorities. With respect to Gentry's third exemption, and this is with respect to the staff DNO's condition to provide equal prominence of reserved and market homes and for the information to be represented equally and fairly. Gentry completely agrees that the authority has a substantial interest in reserved housing and trying to get reserved housing homes built and constructed. And frankly, Gentry has every incentive, I think you can see from the record, to try to do that. But this condition goes too far by requiring just equal prominence. There are terms about, I think, equally and fairly. In Gentry's view, there are some First Amendment issues with respect to this. It's vague, it's ambiguous, the standards are difficult to comply with. We're hearing for the first time, the staff specific focus on the website, and Gentry's, exemptions did not really touch those website issues with respect to, one click over to the next page, et cetera, which is fine. Gentry understands that. Gentry's concern is about mandating that all of Gentry's marketing materials always have equal prominence to both reserved and market under all circumstances, under all market conditions. And given the multitude of types of advertising and strategies, et cetera, that Gentry has and it's used throughout the years, that's problematic in Gentry's view for this board to be dictating those types of requirements. So finally, I'll turn to the third issue, or the fourth issue, I'm sorry, excuse me, with respect to the public facilities dedication requirements. Now, the authorities' Kaulu rules provide that floor area related to reserved housing is subtracted from the floor area for the project for purposes of calculating the public facilities dedication requirements. That's the rule. Under the staff's decision order, the Lycaea garden credits, which are reserved housing floor area for all purposes, is treated basically differently from reserved housing floor area for purposes of the authority's own rule stating that it is subtracted from the public facilities dedication requirements. And that difference is significant, fairly significant. It means that, potentially with all the credits applied, potentially 57,243 square feet of additional regular floor area would be added to Kaulu through this. So instead of a credit that Kaulu currently has, Gentry would be in a deficit for public facilities dedication requirements at this point. And respectfully, that analysis really misapprehends the nature and purpose of the reserve housing credits here. Although in a form of a credit, the reserve housing floor area from Whitehair Gardens is again indistinguishable from the reserve housing floor area constructed on site for purposes of meeting both the reserve housing requirements for Kaulu as well as for calculating public facilities dedication requirements. In Gentry's view, the authority cannot take one position with respect to one role and take another position with respect to the other role. It has to be rational and it has to be in compliance and consistent across the rules. So respectfully, Gentry believes that Gentry's DNO and condition should be adopted on this issue. Thank you again for the opportunity to address Gentry's exemptions. Again, we very much appreciate the board and the staff's time on this. Again, we believe it's important for the board to keep in mind why Gentry came to the board to request this relief and the circumstances to provide timely reserve housing and market workforce housing for this development, and why the board's recognition of the fundamental nature of these credits is important in its analysis. Again, thank you very much. And I apologize if I may take 1 second to consult with Gentry on this to see if there's some additional factual issues they'd like to address with the board at this point. If I may.
Proceed. Council.
Thank you very much, Chair Giga. Respectfully, if it's okay, if I may call Gentry's CEO to kind of inform the board about some factual clarifications in light of the staff's discussion today. Again, this is the first time actually we're hearing the staff's full analysis of this.
Please proceed.
Thank you very much. So we'll call Quentin Machida, who is the CEO of Gentry Homes. Thank you.
Good morning, everybody. Thank you for allowing me to address the board. We appreciate the staff's work. Obviously, we don't.
Yeah, I think we may need to bring you under oath. Just as a.
Okay. Just maybe, confirm that what you're about to testify is truthful and accurate.
Yeah, and then your name and title.
Yeah, my name is Quentin Machida. I'm the president and CEO of Gentry Homes, and I testify that everything I'm about to say is accurate, is true and accurate. Thank you, Mr.
Great, thank you.
Thank you for allowing me to address the board. Thank you guys for all your work. As Brian said, I know it's not over the holidays, and we appreciate that. And obviously, we don't see quite eye to eye. I did want to address some of the things that staff pointed out that I didn't. It was the first time that I heard about that as an argument. But regarding the idea that we wouldn't slow down, we testified that it could affect the pace of our project. Staff disagrees. And I guess I want to put this forward. Without using any credits, in about a month, we would have 28 standing reserve homes, a market value of $19 million. That's going to affect the project. And it's significant enough that we have to consider slowing down. And that's it. I don't, I guess to me it's obvious because of the dollar value. But I just wanted to make that part of the record. Regarding the affordability study, I just wanted to say that we designed the project to meet the requirements of the reserve housing requirements that put on us. Seems to me the affordability study implies that we might be changing some of those requirements. And that's why we believe that is more of a authority thing than something that a developer should take on. And while I'm up here, square foot price, I understand that it is similar, the reserve unit square foot price and the market square foot price. That being said, smaller units typically have a higher square foot price. Our market units, the smaller you go, the higher the square foot prices are. The fact that they're similar means that it is actually priced below market. Yeah, I think that's about. I just wanted to make those things clear.
Thank you, Mr. Machida.
Thank you.
Question, Chair. No, for Mr. Machida, if I may.
Sure.
Just a clarifying. Thank you, Mr. Machida, for coming up. So I just want to focus in on one of your statements that you said, without the use of credit, you would have, in a month, 28 standing units. So, as I think staff pointed out, Gentry has different ways of looking at standing inventory, time on the market, and so forth. So I just want to clarify, when you say that you have 28 standing units in a month, are you saying that if no credits are applied, or even with the 14 credits, 14 units applied?
So if no credits were applied.
If no credits.
If no credits.
Okay, so if 14, if we go with the first tranche and apply credits to that first tranche of 14, you're not gonna have 28 standing units, correct?
Yes.
Okay,
True.
just want to make sure that we're clarifying that.
True, that's true. I'm just trying to say that, I'm just trying to address the point that it wouldn't slow down our, that idea that our, the market is such that we cannot sell the market, so it's not, the use of these credits are not, affecting the pace of our production.
And if I may, Chair, just a clarifying question. So I'm gonna go back to, I think, Mr. Kang's statement too. I mean, we have agreement on the use of, or possibly looking at 2 tranches, right? The timing of the second tranche is at issue, and it's subject to some disagreement. But I want to go back to that and say, if with these, this 2 tranche approach, in your mind, that doesn't diminish in your mind or devalue the credits. I mean, you talk about, the credit system and the reserve housing credit system, but the fact that you're able to come back, at some point with the use of the second tranche, that does not diminish in any way in your mind the credit system.
That's a tricky question.
It's not meant to be a tricky question. It's meant to be a simple question. There's a lot of stuff going back and forth about, the use of the credits, the fact that, our approach may kind of minimize or devalue the use of credit system. So I just want to get to Mr. Kang's, point that there's an agreement about, in concept, about the use of 1 tranche and the second tranche. So if we have that kind of tranche system, 1 and 2 tranche, second tranche, that doesn't diminish the credit system, does it?
So I think in terms of Gentry using the credits, it does not. We recognize that HCA would like to provide as many reserve homes as possible. And, giving a 2-year instead of a 5-year restriction could change the landscape a little bit. So we're willing to work through that. And that's why we're trying to work with you folks on that. That being said, though, it is a tricky question you asked, because if I'm say I'm a separate developer and I want to develop affordable housing within Kailua. I would have to think twice about what are these credits worth and how they will be used. And am I actually, is it saleable to somebody else? What that person is going to be faced with to use the credits? I think those are considerations that should be thought about. So I guess in our situation, I don't think we're devaluing the credits. I think that it is something to consider how it affects future developments in the area. That makes sense.
Thank you. Thank you. Thank you, Mr. Chair. Thank you, Chair.
Council, do you have any further?
Yeah, just one follow-up for Mr. Machida, if I may. So Mr. Machida, with respect to the tranches, let me just ask you this: how does the use of only 30% of the credits at this point affect Gentry's original plans or thinking when it originally came in for the full use of the credits? How does that change Gentry's approach now if it is going to apply 30% of the credits at this point? How does that change Gentry's analysis?
So the original idea was that we were going to use all of the credits, and by using all the credits, given our average rate, let's say, they point out that our rate of sales may not be linear or flat, but just the average rate would take us another approximately 2 years to sell the remaining credits. And we had about, given that time frame, we thought that would put us back on track. What Brian is asking is, how does that change? Well, we're going to apply the 14 credits and if those market, we're hopeful that reducing the timeframes will help to spur sales with reserve housing, and that will help us get back on track. Only time will tell. We don't know how that's going to work out. We don't know what the market is going to be like. It is pretty tough still right now. So hopefully it'll work. I guess that's what I'm trying to say. Thank you very much.
Thank you, Council. We'll move now. Members, any questions or on with regard to the applicant's closing arguments? And then Mr. Machida, if you would mind just staying up there in case members have questions for you. Yes, Member Dubuchel.
Hi, thank you so much for being here. I just have one quick question. When was the last marketing campaign that you folks put out for the reserved housing?
It's
Ongoing. Okay. I just wanted to make sure I answered it properly, but they're ongoing efforts. So we still have radio ads. We still have ads that a Reserve for You campaign on KSSK was a big one that we continue to do. So it's not like we're stopped. It's start, I guess.
Yeah, please follow. There was a testimony submitted by Office of Hawaiian Affairs, and they gave statistics for Kapolei, specifically for Native Hawaiian families, and then we also have the statistic of 20% being for developers providing 20% reserved housing. When I kind of look at those things and I look at the marketing that you're doing, I'm wondering if there could be stronger marketing in the Kapolei area, such as campaigns with OHA to reach out to their Native Hawaiian families, or campaigns with Council for Native Hawaiian Advancement, which is now known as the Hawaiian Council, to target those families because their median income does meet your requirements. And if you go after the market that the reserved housing is set for, I'd like to see if we could look at, if there's any sort of, success when it's targeted to maybe a more specific population. I think the reserve housing credits, as we all know, and have consistently stated, are there for, a specific demographic. And by removing that housing credit from Kaulu, taking from Wakea to satisfy Kaulu, it does in a macro scale seem to not afford that specific demographic an opportunity. So I would ask and see if you folks would be willing to try a different marketing strategy, to be a little bit more targeted.
Okay.
Yeah.
We'd be open to that. But can I make a comment?
Yeah.
Our attorney testified that we believe that it's a good time to use the credits. And it's because, you see, when we have a really confined market, it makes sense that we reserve homes for people with certain income brackets, because so that it doesn't sell out. And we don't want them to flip it, so we put restrictions on them. In this case, we have a market where there are a lot of inventory because the market is struggling. So we believe that to use the credits now is a good thing, because we're not taking away opportunities. Or, they still have opportunities to buy homes around and near the area. And that's our general feeling. We believe that somebody's going to use the credit at some time. We think it's an appropriate time to use it.
Thank you, Member Duvershell. We'll go to Member Anderson and then we'll go to Member Stritz. Member Anderson.
Thank you. Thank you for your testimony today. Just looking at the entire picture, if there are no changes to the HCDA staff recommendation, are you against, would you recommend we vote against this today, or do you need more time for things to work out some of these details? It's very difficult for a board to handle all of these variables.
I wouldn't say, I guess if you're saying you're gonna deny it or approve the staff's recommendation, the staff's recommendation does provide for the use of 14 credits. We don't agree with all the stipulations, but that would help the deal. That answers your question.
Thank you very much.
Thank you, Member Anderson. Member Stritz.
Yeah, I was just trying to get a little bit more understanding for the request to add in the time period under, number 7. Do you want to expand on that?
Sure. So Gentry's position is that in addition to the unit count threshold, that Gentry be able to come in within a year. So whichever occurs first. So, if Gentry sells the unit count threshold, it would be able to come in. But if the year elapses first, before Gentry is able to sell those units, then it would also be able to come in before the board. Because again, no one knows for sure, exactly what will happen. And Gentry's concern is that, if, unfortunately, the staff is incorrect, with respect to the absorption rates and the sale of the reserve housing homes, that year period provides a good safeguard to mitigate the risks for the project at that point, so that the board can learn about what's going on and potentially, if the board is inclined to do so, provide further relief at that point. We believe that makes a lot of sense versus just adhering strictly to the unit count threshold. And if Gentry is not able to come back, within a reasonable time, that presents, as Mr. Machida, I think, indicated, some significant risk for the project.
Okay, yeah, so it seems like it's just another option, minimal times period, and then it's still at the discretion of the chair to add it to the agenda. after the request comes in, right?
Yeah, I mean-
Or can the board to like defer it?
Right, I mean, our request would be at least in this DNO to allow Gentry to appear before the board.
Yeah.
I think where the board has the discretion, obviously, is to decide whether that's, appropriate or reasonable request at that point within its discretion, within the bounds, obviously, of the law, et cetera. So,
Thank you.
sure.
Thank you, member Strikes, member Evans.
Brian, on staff's issue number C, modify content requirements for marketing, they're agreeing with your First Amendment argument, but they've also added, append the phrase, Gentry shall use its best efforts to market the reserved housing units and make the materials and resources easily accessible and navigable to users. Are you okay with that change?
Yes, subject to Gentry's comments. Yes, I mean, those are, I believe, changes to the website, which Gentry, I believe, has agreed to adjust the website, yes.
Okay.
Thank you, member Evans. Members, any other comments or questions? Question for council on exception A. Would you be open to having the option to come back with a lower amount of sales? So right now you can come back after, I think, 15,
14.
yeah, 14 sales. What if the board were to just reduce that amount to like 7 sales or something? Would that satisfy you, and then you can sort of time things out easier?
Sure, if you don't mind.
Yeah, please. Yeah.
She got this very quickly. I mean, that's the way off that I think it's really very much. Yeah, thank you, Chair Higa, for that question. Gentry believes that the time threshold makes the most sense overall. However, if that is the decision of the board, on the 7 units, for example, and I believe the threshold is 15 units, but if it's dropped to, for example, 7 units, Gentry is willing to accept that threshold.
Members, any other comments or questions? Okay, seeing none, thank you, applicant.
Thank you very much.
We'll move now to public testimony. Since the notice of the public hearing was published on Thursday, October 30th, 2025, and written testimony invited, as of today, the HCDA has received a total of 7 written testimonies from the public regarding the project, 2 in support and 5 for comments only. At the presentation public hearing, 3 individuals provided oral testimony in support of the project. We will now take verbal public testimony. Speakers will be called upon to testify in the order in which they have signed up. Do we have any persons pre-signed up to testify? Okay. Do we have any persons in person or online wishing to provide testimony?
None online, Chair.
None online, none in person. Seeing none, we will close public testimony. We'll now continue with deliberations and decision-making. Members, please indicate by saying yes or no to signify that you have personally received and reviewed the entire record for the proposed amendments to the development permit and are prepared to deliberate. Let the record reflect that the following Kalailoa members are prepared to deliberate on the item. I am prepared. Vice Chair Ishii.
Yes.
Thank you. Secretary Lidstone.
Aole.
Aole, no. Okay. Thank you, Secretary Lidstone. Member Miranda Johnson.
Yes.
That was no. That was no. Thank you, Member Anderson.
Yes.
Thank you, Member Evans.
Yes.
Thank you, Member Strikes.
Yes.
Thank you, Member Duvachel.
Yes.
Thank you, Member Gordner.
Yes.
So we have 8 prepared, and then Secretary Lidstone not. Is there a motion for the authority to convene in recess for the purpose of deliberations?
What does that mean?
So we're gonna take our recess and.
Oh,
Sorry, take a recess and deliberate.
do we actually need a motion to take a?
I think we do probably do a motion. This is the motion
Take recess.
So moved.
Thank you, Member Evans. Do I hear a second for the motion moved by Member Evans?
Second.
Member Duvashel, sorry, Member Gordner, she beat you to it. Members, is there any discussion on the motion? All those in favor of the motion, we'll just do a voice vote. Aye. Any opposed to the motion? The motion passes. I request that we are joined in the recess by the Executive Director, Craig Nakamoto, Chief Financial Officer, Garrett Sasaki, Director of Planning and Development, Ryan Tam, Community Outreach Officer, Francine Murray, HCDA Secretary, Salem Calais, Board Secretary Armaine Pamakter, HCDA Planner Jonathan Chinnan, and Deputy Attorneys General Kelly Suzuka and Kevin Tong. Board members and requested staff will be invited to join virtually. There will be a link provided for you to click. In-person members of the public and non-invited staff, if we could please ask you to exit the boardroom, we will notify you when the board members are ready to reconvene. And when the hearing reconvenes, a request for a decision-making motion will be made. All right, we estimate that the recess will last approximately 20 minutes.
Thank you. Great.